Hey there, let me ask you a question real fast. Name any other amendment besides the Second Amendment in the Bill of Rights that comes up in a presidential debate, a school board meeting, a Supreme Court case, and just your normal family argument at Thanksgiving, all in the same year. You can't, because there isn't one. The Second Amendment is unlike anything else in the Constitution. It is the amendment that half the country believes is under constant attack, and the other half of the country believes doesn't go nearly far enough in allowing restrictions. It's been called everything from the cornerstone of American freedom to the source of public health crisis. Here's what I'm gonna do today. I'm not gonna tell you where to land on this. What I'm gonna do is give you the actual text, the real history of why it was written, every major Supreme Court case that has defined what it means, and the hard data on where America stands right now. Because before you can have an opinion on the Second Amendment, you should actually understand it. Let's get into it.
He's got a point, you know.
All right, let's start at the very beginning, the actual text. And I mean actually read it, because most people in this debate have never done that.
Read? We don't really do much read.
Here it is in full. Quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. End quote. 27 words, that's it. And those 27 words have generated more legal and political debate than almost any other sentence in American history. Now here's where it gets interesting. The amendment has two distinct parts. The first part, a well-regulated militia being necessary to the security of a free state, is what legal scholars call the prefatory clause. It provides context. It states purpose. The second part, the right of the people to keep and bear arms shall not be infringed, is the operative clause. This is the part that actually confers the right. For most of the 20th century, legal scholars and courts debated which clause was doing the heavy lifting. Was this a collective right tied to a militia service, or an individual right belonging to every American citizen, regardless of militia membership? That debate was settled definitively by the Supreme Court in 2008. And we'll get to that. But first, to really understand what this amendment means, you have to understand why it was written in the first place. And for that, we need to go back to 1775. All right, it's April 19th, 1775. British General Thomas Gage has a problem. The colonial militias have been stockpiling weapons, muskets, cannons, gunpowder, in a town called Concord, Massachusetts. His orders are clear: seize those weapons, disarm the colonists before this rebellion gets out of hand. What happens next?
The redcoats are coming!
The Battle of Lexington and Concord, which is widely considered the opening shots of the American Revolution. But there's a part that it often gets lost. The reason the British were marching that day was to specifically confiscate weapons. The founders remembered that vividly. When they sat down to write the Bill of Rights back in 1789, they weren't writing in the abstract. They were writing from lived experience. Men who had watched the government attempt to disarm its own people as a precursor to tighter control. They wanted to make sure that could never happen again in America. Now, there's another layer to this that most people do not know. The founders were also deeply uncomfortable with the idea of permanent standing army. They had just spent years fighting one. They believed, and wrote extensively about this, that a professional standing army controlled by a central government was one of the greatest threats to liberty. Their solution for this was the armed citizen. The idea was that an armed population could serve as a check on government power, that no government would dare become tyrannical if the people had the means to resist. And they weren't working from scratch on this. They drew directly from the English Bill of Rights of 1689, which had established over a century earlier that Protestant subjects had the right to bear arms for their own defense. The founders took that tradition and enshrined it in the new American Republic. Now, I want to be honest about something here. There's a legitimate scholarly debate about how much weight to give the check on tyranny argument in a modern context. The founders were writing for a world of muskets and state militias, not the world we live in today. That tension between original intent and modern application is exactly what the courts have been wrestling with for the last 2 decades. And that brings us to the case law. Because if you really want to understand where the Second Amendment stands legally today, you need to walk through the Supreme Court decisions, starting with the landmark case that changed everything in 2008.
Please rise. Court is now in session.
All right, for most of American history, we're talking nearly 200 years, the Supreme Court almost never weighed in on the Second Amendment. There were occasional cases, but nothing definitive. That all changed in 2008. District of Columbia versus Heller. Dick Heller was a special police officer in Washington, D.C., who wanted to keep a handgun at home for self-defense. However, D.C. had one of the strictest gun laws in the country, a near total ban on handguns, and a requirement that any lawfully owned firearms be kept unloaded and disassembled. Heller sued. In a 5-4 decision, the Supreme Court ruled in his favor, and in doing so, answered the question that had hung over the Second Amendment for 2 centuries. The court held that the Second Amendment protects an individual's right to keep and bear arms completely independent of service in any militia. For the first time in history, the Supreme Court had definitively said, This right belongs to you as an individual. But, and this is critical, Justice Scalia's majority opinion also made clear that the right is not unlimited. The court explicitly said that longstanding prohibitions on firearms, like restrictions on felons or the mentally ill, owning guns, or laws against carrying weapons in sensitive places were still constitutional. The right is real and individual, but it has boundaries. Case number 2, McDonald versus the City of Chicago. Heller applied specifically to Washington, D.C., which is the federal district. That left an open question. Did the right apply to state and local governments as well? Chicago had a handgun ban similar to DC's. Otis McDonald, a retired maintenance worker on the South Side, challenged it. In 2010, the Supreme Court answered yes. Through the 14th Amendment's Due Process Clause, the Second Amendment now applies to every state, every city, every local government in the country. No exceptions. Next case, NYSRPA versus Bruin. Fast forward to 2022, New York had a law requiring anyone who wanted to carry a handgun in public to demonstrate a specific documented need, what they called proper cause. In practice, this means ordinary citizens were routinely denied permits, even if they had no criminal record. The Supreme Court struck this down 6-3. The court extended Second Amendment protections to carrying firearms in public for self-defense, not just in the home. But more importantly, Bruin created a brand new legal test that lower courts now have to use when evaluating any gun regulation. The law must be consistent with the historical tradition of firearm regulation at the time of the founding. If you can't find historical analog from 1791, the regulation is on shaky constitutional ground. And finally, the case of the United States versus Rahimi. Just a couple years ago, the court had a chance to clarify what Bruin actually means. Zacky Rahimi was a subject to a domestic violence restraining order. The federal law prohibited him from owning a firearm. He challenged that law under Bruin. The court upheld the law 8-1, one of the most lopsided Second Amendment decisions in recent history. The majority said that while Bruin requires historical grounding, courts shouldn't be looking at an exact match from 1791. They should look for analogous principles, and there is a long historical tradition of disarming individuals who pose a credible threat to others. So where does that leave us? The right is individual. It applies nationwide. It extends outside the home, and it has limits where history supports them. That's the legal framework as it stands today. Okay, let's talk numbers, because this conversation deserves actual data, not talking points. According to Pew Research, approximately 32% of American adults personally own a firearm. About 44% live in a household with one. And there are an estimated 400 million privately owned firearms in the United States. That's more guns than people. Now, let's talk about gun deaths, because this is where the conversation often goes sideways. In 2024, the CDC recorded 44,447 gun-related deaths in the United States. That's a real number, and it demands serious attention. But here's the breakdown that most media coverage skips over. 62% of those deaths, roughly 27,600, were suicides. About 35%, just over 15,000, were homicides. The remaining 3% were accidents, law enforcement incidents, and undetermined circumstances. Why does this breakdown matter? Because suicide and homicide require very different policy responses. If you're trying to address gun violence without distinguishing between those two categories, you're not really solving either problem. Here's another data point worth knowing. Gun homicides have now dropped 14% 2 years in a row, from 2022 to 2023, and again from 2023 to 2024, bringing the total down from nearly 21,000 at the pandemic peak to just over 15,000. And early data from 2025 suggests homicides are down another 20% so far. The problem is serious, but the trend is moving in the right direction and accelerating. The one area moving in the wrong direction, unfortunately, is gun suicides. That number has risen for 6 consecutive years, and it hits its highest share of the total gun deaths in over 25 years in 2024. That's a different conversation than homicide, and it deserves its own serious attention. And when you ask gun owners why they own, 71% today say protection is the primary reason. That's a massive shift from the 1990s, when the majority cited recreation. Americans' relationship with firearms and their sense of personal safety has fundamentally changed.
Okay. Safety first. Safety is first, all right?
I've got one more number for you. 22 million Americans currently hold concealed carry permits. And 27 states have adopted what's called the constitutional carry, meaning no permit is required. The legal landscape on carrying firearms in the public has shifted dramatically in the last decade. So here's where we are. The courts have given us a framework. The right to keep and bear arms is individual. It applies nationwide. It extends to public carry, and it has constitutionally permissible limits. That's settled law. What isn't settled, and what is being actively debated in legislature and courtrooms right now, is everything inside that framework. Background check systems and how comprehensive they should be. Red flag laws that allow courts to temporarily remove firearms from individuals deemed a threat. Age restrictions.
Oh my God, I shot my eye out.
Restrictions on specific types of weapons and magazines. These are real. unresolved legal and policy questions. And reasonable people, including justices on the Supreme Court, disagree on where the line should be drawn. What I encourage you to take away from this video is this: the Second Amendment debate in America is not simply guns good versus guns bad. It's a genuine constitutional question about the balance between individual rights and the collective safety. A question the founders wrestled with, that the courts have been refining for over 2 centuries, and that we as a country are still trying to work out. Understanding the history, the case law, and the data doesn't tell you where to land politically, but it does make sure that wherever you do land, you got there honestly. So that's the Second Amendment. So, if you found this useful, please subscribe, because in next episode, we're covering the Third Amendment.
Pick number 3, my lord.
It's the one everybody skips, and it turns out it's more relevant to modern life than most people realize. Thanks for tuning in. I look forward to seeing you on the next episode.